Police came up to a house and began to persistently knock on the front door and windows for 2.5 minutes. The knocking rose to the level of heavy pounding until the resident opened the door and eventually consented for the police to come in. But would the initial knocking be construed as an illegal seizure under the Fourth Amendment, and thus anything that followed must be suppressed under the fruits of the poisonous tree doctrine? Well, we'll find out today. I welcome you to LAWSTACHE channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California. If you're new to the channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and some other items. Thanks for watching.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
Today we're discussing a district court case, United States versus Carlos Velasco. Now, if you've been paying attention to my channel and watching it for a while, you know that I mostly discuss appellate and Supreme Court decisions. They seem to be a little more consequential, but it makes a lot of you believe that district court judges don't read anything, don't make good decisions, and that's simply not true. And so today, to break that misconception, we're going to discuss and review a district court opinion. So here, officers received an anonymous tip that a certain residence was used as a stash house, a location where large amounts of narcotics are being stored. The officers went to the scene and interviewed a few neighbors. A few neighbors told them that they usually don't see anybody around the house, and it is usually pretty quiet. But when they do, individuals would usually use the side door through the side gate instead of the front door, which they thought was suspicious. The neighbors also told the police that they're afraid of retaliation, so they didn't want to participate in this case. Now, with these observations, with an anonymous tip and the interviews with the neighbors, the officers decide to conduct a knock and talk. Now, I've discussed the knock and talk exception to the Fourth Amendment warrant requirement on this channel many times. We'll discuss it again today. But if you don't know, or if you're interested in this exception, I urge you to watch the other videos after this one. I will link some of them in the description below. So around 9 p.m., officers decide to conduct a knock and talk at this residence. They arrive in plain clothes, but the officers had their lanyards that had the badges on the front. A detective came up to the front door. A few other officers went to the back. The officers in the back right away started to smell cleaning detergent. Now, the detective began to knock on the front door, which had a metal screen door, for 2.5 minutes. Now, the knocking rose to the level of heavy pounding. Later, the detective testified that although he said that this is police and knocked, and it wasn't a command to open the door, but with his heavy pounding on the door, he testified that an individual inside would not feel free to ignore his commands. Meaning, he would have continued to knock on the door until somebody answered. And eventually, Mr. Velasco answered the door. Initially, the detective and Mr. Velasco spoke through the screen door, but the detective wanted to go inside, and he wanted to talk to Mr. Velasco further. Eventually, Mr. Velasco opened the screen door and walked out onto the porch. They spoke for about 15 seconds, where the detective consistently asked Mr. Velasco to go inside the house because he wanted to talk further. Mr. Velasco explained that he didn't want to go inside because he didn't have any furniture and he would rather speak outside. But eventually, Mr. Velasco turned around and began to walk into the house sort of consenting to the officer to follow, which he did. But the officer also signaled to other officers to follow him. Now that all the police officers were in the house, they conducted a protective sweep and they found some marijuana, they saw a firearm, and some packaging material. With that information in hand, they had probable cause to obtain a warrant, which they did, and they found some more incriminating evidence. Now, we know that we have a warrant, but prior to obtaining a warrant, the detective believed that he was operating under the knock and talk exception. And so he believed that he didn't need a warrant. Now remember, the Fourth Amendment protects you against unreasonable searches and seizures. And generally speaking, officers need to have a warrant before they conduct a search. Now here, of course, like I said, they eventually had a warrant. But the question becomes, was that initial entry and even the knock on the door legal under the Fourth Amendment? So let's talk about the knock and talk exception. The general rule in the Ninth Circuit concerning knock and talk encounters is absent express orders from the person in possession against any possible trespass, there is no rule of private or public conduct which makes it illegal per se or a condemned invasion of privacy for anyone openly and peaceably at high noon to walk up the steps and knock on the front door of any man's castle with the honest intent of asking questions of the occupant thereof, whether the questioner be a pollster, a salesman, or an officer of the law. In other words, a knock and talk is a consensual encounter. Consensual encounters between police officers and citizens are not seizures. In Cormier, the Ninth Circuit identified two sets of coercive circumstances that would transform a knock and talk into a seizure. Number one, if the police compelled an occupant to open the door under the badge of authority. And number two, if the police were unreasonably persistent in attempting to gain entry. The court further noted that a nighttime encounter weighs in favor of a seizure. In this case, the district court said that the police were unreasonably persistent in knocking on the front door and the windows for 2.5 minutes. The knocking rose to the level of heavy pounding. So it is accurate to say that the police would not leave until somebody answered the door. By the way, this was at 9 p.m. So we're talking about nighttime. Again, nighttime usually means that this is not a knock and talk, but rather a seizure. And the district court says that the command to open the door was just that. It was a command. It was not a request. Because again, the officers would not leave until somebody came up and opened the door. For these reasons, the district court says that this is a seizure under the Fourth Amendment. And seizures must be supported by reasonable cause, reasonable suspicion that criminal activity is afoot. Here the government says that the anonymous tip plus the officer's observations, conversations with the neighbors, all supplied sufficient reasonable suspicion that criminal activity is afoot. So let's discuss all of these step by step. First, let's talk about the anonymous tip. To give rise to reasonable suspicion, an anonymous tip must include a range of details and predict future actions by the suspect that are subsequently corroborated by independent police observations. Courts will uphold an investigatory stop based on a tip or other secondary information only when the information possesses sufficient indicia of reliability that are independently corroborated by the police. An informant's veracity, reliability, and basis of knowledge are highly relevant in determining whether reasonable suspicion exists. The anonymous tip in this case did not provide more than bare allegations of criminal activity, and it was impossible for the officers to corroborate or dispel any of the information that was provided by the anonymous tip. So this is not reasonable suspicion. The next thing is the officer's observations. Before conducting a knock and talk, the officers arrived to the scene, they saw the house, They saw the side gate, they saw the front door, they saw the fact that it had a metal screen door. They also noticed that the front windows were covered with either blinds or curtains, and those were closed so you couldn't see inside. And there was no vehicles in the driveway. Again, the district court says that having curtains on the window is not reasonable suspicion that criminal activity is happening inside. Many people put curtains and blinds because they want privacy and they don't want neighbors or other individuals snooping around and looking into their home. The fact that the house was quiet and did not have any vehicles in the driveway, again, the district court says it is weird and strange that the officers are bringing that up because the absence of vehicles in the driveway does not suggest criminal activity. Instead, it suggests that there is no activity whatsoever, whether it is criminal or otherwise. And now let's talk about another issue, the smell of detergent that other officers were smelling when they approached the house from the back. Now, it might suggest that somebody's cleaning inside and trying to mask the smell of marijuana or other narcotics. But let's talk about first the collective knowledge doctrine, because after all, the detective up front did not know about the smell when he was knocking on the door and initially made the conversation with the defendant. So what is the collective knowledge doctrine? Under the collective knowledge rule, information known to other officers may support a finding of reasonable suspicion even if the specific facts known to them are not communicated to the detaining officer prior to investigatory stop. However, there must be at least some minimal level of communication among the officers in order to apply the rule. In this case, the officers who detected the order did not communicate that to the detective up front. And so the court says there is no reasonable suspicion to enter based on this factor because, again, the officer up front, the detective, did not know about the smell. And if you take all of these factors as a whole, the district court said that there is no reasonable suspicion that any criminal activity was happening inside. And instead, what the officers should have done is some more investigation, create probable cause, figure out what was happening in the house and whether it was really a stash house, and then obtain a warrant. So knock and talk exception does not apply here. And finally, briefly, consent. Well, consent doesn't apply because it is followed after the illegal seizure. And so that consent is not voluntary. Now you understand that even a simple knock on the door can be deemed a seizure under the Fourth Amendment, and all the evidence that's found in the house must be suppressed under the fruits of the poisonous tree doctrine. If you learned something about the knock and talk exception, the Fourth Amendment, consent, and all of these other things we've discussed today, I hope you hit like, subscribe to my channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to LAWSTACHE.com and check out some of the merch, including the Do Not Arrest This Person t-shirts, hats, and some other items. Thanks for watching. See you next Wednesday.